going to talk to one of my colleagues real quick. Tim, I see you there, but I've also got Chris Harris on, and I think everything is good as far as the live stream goes. So
You're
I think
live.
from a communications perspective, we are good.
Yep,
We're just about ready to rock and roll here.
we're
I
good to
think
go.
okay, well. Well, great. It is 4 o'clock. We have opened the gate, so to speak. So I think I'm gonna get us started here. First of all, to everyone joining us this afternoon, welcome to the latest of our Fire Faculty Network webinars, which has been a really good and useful way of us to continue bringing programming to our faculty. In a time when the usual in-person activities have been a little bit constrained. It's something that even as times return more to normal and we are able to get back to our usual conference type programming, it's something I think we're going to continue doing because we've gotten a lot of value out of it. So we're going to continue doing it through the spring, at least through the summer. We've got a couple of more really good programs lined up that I'm excited for. So thanks for tuning in, and as always, stay tuned for announcements for future programming from us. I will get things started. For those of you who haven't tuned into one of these before, I'm Peter Bonilla. I am the Vice President of Programs at FIRE, the Foundation for Individual Rights in Education. I've worn a lot of hats in my time at the organization. I marked 13 years at FIRE in the last couple of weeks. And these days, a lot of my portfolio is overseeing our faculty programming, faculty outreach and development. Running our fall conference, which I will send some links in the chat about, as well as some other information that I will kind of seed out through the discussion today. But I want to get as much out of my own way as I can. I'll just throw in two little bits of housekeeping. One, I will send a link for faculty network members or prospective members who are tuning in to take our annual faculty network survey. We are running it through the end of next week, through Friday, May 7th, and we are, as part of the incentive to complete the survey, which shouldn't take more than about 5 or 10 minutes, giving out 25 Amazon gift cards valued at $25 a piece. And I will send that link. And also, we are continuing to take applications for our Faculty Network Conference, which we are planning on bringing back this fall. We are planning on doing it in Chicago. I will send a link to our conference page as well in the chat field. And that's about it from my end. So again, I'm going to hand it over to our two panelists. And today, again, we're very pleased to have first Ronnie London, who has recently joined FIRE as the director of our new Faculty Legal Defense Fund. He is a First Amendment attorney who is new to FIRE in terms of being on our staff, but pretty well known to FIRE in terms of his assistance through a number of years of our litigation-related projects, and he has helped see a lot of our cases through, and brings a lot of experience that he can call on in that regard. He's going to talk a little bit about his new work overseeing our Faculty Legal Defense Fund, and take questions from people as they have them. And I'm also very pleased to have Phil Beverly, professor at Chicago State University and a former plaintiff from one of our Stand Up for Speech litigation project cases at Chicago State University. And he brings, well, the experience of having been a faculty plaintiff, and a lot of very valuable, hard-won perspective that comes with that territory. So we're really pleased to have Phil with us, especially as until about 15 or so minutes ago, I wasn't 100% sure that Phil was going to be able to be with us because he had an emergency root canal surgery this afternoon. So Phil gets all the points for today. I'm very glad to have him with us, and I'm very glad to bring Phil and Ronnie together. From their days in our old Stand Up for Speech litigation project. Ronnie, we'll start first with you, and I wonder if you could, in addition to kind of talking about the Faculty Legal Defense Fund and the fund's mandate and just kind of its mechanisms. Talk a little bit about, let's start a little bit before that and talk about kind of how you got to FIRE, what brought you here, kind of your First Amendment litigation background that made you the man for the job.
Sure thing. So yeah, thanks for setting this up. Thanks very much for Phil for being here. We'll give him his hazard pay today. And I am the director of FIRE's new Faculty Legal Defense Fund. As Peter mentioned, I am newly employed by FIRE. I was brought on March 1st in conjunction with creation of the new program, but I'm not new to FIRE. I come here after about 25 years in private practice, the last 18 at the law firm of Davis Wright Tremaine, doing primarily First Amendment litigation to protect all types of speech involving pretty much every media sector, advertising, and practically all communications platforms. That included, as Peter mentioned, working with FIRE for about last 7 or 8 years, litigating cases involving students, student organizations, and faculty. Most of those cases came in FIRE Stand Up for Speech campaign that targeted college and university speech codes, free speech zones on campus, retaliation against student and faculty speech, and various other transgressions against the First Amendment and fun and games by university administrators and institutions. One of those did involve Professor Phil here and his now retired colleague, Bob Inez at Chicago State University, and he'll tell you a little bit more about that. But during the Stand Up for Speech campaign, I gained a lot of experience kind of assessing faculty member cases and that of students also, developing for litigation, working with faculty and students as plaintiffs and witnesses, preparing them for depositions and things like that. Out of almost 20 Stand Up for Speech cases, most of them settled early on with changes in university policies, payments to the plaintiffs and payment of FIRE's attorney's fees, with only a few, unfortunately, Phil's case being one of them, proceeding to full litigation. But in those cases, they involve victories as well, like with CSU and with Iowa State, which was a student case, where for their troubles, the colleges entitled themselves for fighting with us the right to enter settlements in the 6 figures in payments to the plaintiffs and the attorney's fees. Beyond work for FIRE, I guess the most prominent case I worked on was we were counsel for CBS in the wake of the Janet Jackson, Justin Timberlake Super Bowl. I probably hold the claim to having watched that footage more than anyone else in the world over the course of that litigation, and the appeals ultimately going up to the Supreme Court and the Third Circuit finding that the FCC improperly fined the network and making them give their money back. Writing that letter asking for the money back was one of the great thrills that I had as a First Amendment lawyer. When FIRE came up with the idea for the Faculty Legal Defense Fund, we thought it was, really a natural fit given my experience, especially my experience with FIRE, and here I am. The idea behind the Faculty Legal Defense Fund is that, and I really doubt that I need to tell anyone who's tuned in for this, but over the last few years, the political and social climate has made it increasingly a fraught time for college and university faculty and their First Amendment rights to free expression and academic freedom. So FIRE created the Faculty Legal Defense Fund, FLDF, to address the growing number of faculty that have been coming to us when their rights are violated, in order to provide free legal assistance to faculty members facing censorship or retaliation for their expression. And to better understand how FLDF is structured, I think it's useful to kind of see how it fits into FIRE's overall portfolio. We have the Individual Rights Defense Program, IRDP. That's FIRE's core defense program that targets violations of fundamental civil liberties at colleges and universities. IRDP reviews hundreds of potential rights violations every year and seeks remedies through a variety of means, whether it be direct communication with school leaders to demand reversals of actions or rectification of violations of constitutional rights, targeted media campaigns, freedom of information requests that expose publicly schools' actions, and other creative advocacy. And IRDP is really our big tent in that it assists individual students, professors, student media, student organizations, at both public institutions required to follow the Constitution and private institutions that commit to protect civil liberties as a matter of policy or contract with people that they hire and that they teach. We also have a litigation program, which is a longstanding and growing litigation team that brings cases on behalf of the same constituencies that IRDP serves, and also files friend of the court briefs in cases of significance. They also engage outside lawyers to bring and try cases involving educational free speech, expression, and academic freedom. Stand Up for Speech is just one example of that. FIRE also has legislative and policy arms, high school, campus policy reform, and other arms dedicated to even more specialized aims. But the idea of adding FLDF to this, the Faculty Legal Defense Fund, is that in the current environment, the frequency of actions being taken either against faculty or threatened to be taken against faculty in ways that are, not consistent with their constitutional rights, and the resulting demand, a potential need for legal assistance, have really grown to a point that we wanted to be able to do even more than the legal network of IRDP is already able to do. IRDP's legal network is dozens and dozens of attorneys across the country who have volunteered to sign up and be available on a pro bono basis for referrals out of FIRE when an attorney needs to step in. But it's gotten to the point now with the volume that simply relying on lawyers giving their time for free to respond to this significant demand isn't always going to be feasible or abundant enough to meet the need with what's going on. So kind of working with like-minded folks at the Stanton Foundation, who with a generous grant made it possible to have the FLDF, we're creating a nationwide network of attorneys who the fund will actually pay for legal representation for faculty when their First Amendment rights are being threatened at no cost to the faculty member. And the goal here is for these participating attorneys to be kind of early responders, so that they'll be licensed in the areas that are geographically proximate and jurisdictionally appropriate to where any given faculty member might find themselves in trouble, so that lawyers and faculty can be quickly connected to start addressing the matter, ideally as early as there's a threat to potential rights violation, not wait even for the rights violation to happen. And the hope is that by getting plugged in quickly and early in this way, the attorney can take steps to get the faculty member a good resolution of the issue before it becomes something that needs to be litigated, or if that can't happen, for there to be a structure in place for if litigation becomes unavoidable. So here's how FLDF works. At the present, it's open to faculty at public colleges and universities. We may eventually be able to expand it to private institutions that make commitments to honor civil liberties. But for now, we're just focused on public institutions. IRDP is still there for private colleges and universities. And faculty members who think that their First Amendment rights are being violated or might be violated can submit an inquiry to FLDF through FIRE. We use the same submit a case page at the FIRE website that's always been available, primarily for IRDP, but now it does double duty for FLDF. We're kind of in the nascent stages of the FLDF program. Eventually, we will have our own web page at the FIRE site, and we will have a way to get directly to the submit a case page from there. But we also have a hotline that is just for FLDF. It's answered 24 hours a day. The number is 254-500-FLDF. That's 254-500-3533. That you can call and make an inquiry the same way. Regardless of how the inquiry comes in, we'll quickly review the matter. We've got a legal fellow here for all the intake that's dedicated to just FLDF. We'll take a look at it, confirm that it's right for FLDF. If it's not, see if it's appropriate for IRDP. But really for FLDF, it can be pretty much any incursion on free speech rights or academic freedom protected by the First Amendment that is being threatened by the institution in any aspect of its authority or power. And it can also include employment and contractual issues that get wrapped up in these First Amendment claims. It includes core classroom teaching, which of course is protected by the First Amendment. Any other aspect of your pedagogy. There was recently an appellate court decision, one in which Fire filed an amicus brief that basically explained that pretty much the entire way that a professor comports themselves in the classroom is legitimately part of their pedagogy. And that includes not just what they say, but how they say it. It can involve your research and publishing. It can involve even your extramural speech. I mean, we see lots of instances now where faculty members say something on Twitter in their personal capacity, and the next thing you know, it's a tempest in a teapot and the institution is getting involved. And I think the first few matters we've referred out of FLDF to attorneys kind of illustrates this. We have one case where a university professor was stripped of his department chair position for standing up for a colleague who was facing termination over his own writings. We have another case where a community college adjunct was terminated after he directed his students to his YouTube page for instructive purposes because the video feed that the college was providing was a little bit, glitchy and sketchy. But there was also other unrelated stuff personal to him on the YouTube page that the administration found objectionable, even though he didn't direct the students to that material. Recently, we found counsel for an instructor who was part of a lesson plan about confronting uncomfortable concepts, made a statement unfavorable to BLM to illustrate the point as part of a larger discussion that was really about confronting an idea like that. And if you listen to the entire lesson, it was patently obvious that she was fully in support of BLM and that she was not criticizing at all. But that one clip of those 15 seconds was extracted by a student and went viral. And the school's already issued 2 statements that have said it's going to get investigated without even having looked at the full video themselves. Once the matter is deemed appropriate for FLDF, we find a lawyer in a nearby area who has agreed to be part of the network, and we connect the attorney and the faculty. We get everybody engaged as a client of the attorney. And what FLDF does is it'll pay for the first 20 hours of attorney time to address the situation. And that can include everything from the attorney getting up to speed, reviewing any relevant documents, the faculty client becoming informed of their legal and other options. The lawyer could maybe attend meetings at or with the institution if that's appropriate, or there could be negotiation or correspondence toward resolving the matter. After the first 20 hours, the lawyer and FLDF will have a little check-in. We'll see where things stand. We'll see if significant further work is needed. If it is, the fund can pay for up to an additional 20 hours of attorney time for a total of 40 to try and get the matter resolved in a way favorable to the faculty member. If after 40 hours, we have another check-in and it appears that substantial further work is needed, or that really the only way it's going to get resolved in the favor of the faculty member is that litigation is going to be required, the matter can be submitted to an FLDF litigation committee for review. And if the committee approves the matter, then the fund will pay the attorney's fees to have the case litigated or such other further work that's necessary to resolve the issue. And all of this, of course, is at no cost to the faculty member. But the idea is to, wherever possible, as quickly as possible, get a good resolution, head constitutional problems off at the pass, and make sure that nobody's kind of hanging out there having their rights threatened and not really having anywhere to go for guidance.
All right, well, Ronnie, thanks very much for that. Phil, I'm going to get to you in just a moment, but before we do, because I've seen 1 or 2 of them come in, people on this webinar, at any time, feel free to send your questions into the Q&A field, and we will start getting to them in hopefully with a good 20 or 25 minutes to spare during this webinar. I will also, for for the questions we inevitably don't get to answer, I'll make sure to follow up with attendees with a little bit more information, more sources that they can consult. We will have this webinar recorded and up on our website and on our YouTube page in the next few days, so you'll be able to watch this again as well. But again, feel free to start sending your questions our way. I will also, people can always email me or Ronnie. I will give our email addresses. I'll add them to the chat field here. But now want to make some time for Phil Beverly. And I asked Phil to join this webinar this afternoon because well, he has a story to tell for one, in terms of his experience having been a plaintiff during what turned out to be one of, as Ronnie said, our more drawn out and protracted stand up for speech litigation project campaigns. It is something that maybe could have gone in a different direction. Had the Faculty Legal Defense Fund been around at the time when Phil and Professor Bayanes were having their issues at Chicago State, though, then again, having heard Ronnie's pitch, it may well have been the kind of case that would have taken more than those 20 or 40 hours to resolve. Phil, I know that the experience having served as a plaintiff, I'm sure it was an eye-opening one. I don't think anyone gets into academia so that they can one day be a plaintiff in a First Amendment lawsuit against their institution. So I wonder if you might share with our attendees kind of a little bit about the background of your case at Chicago State University, and also just kind of share some of the things you came away with, the impressions you had, things things that you would advise other faculty on if they're considering stepping into those same shoes as you. I'm happy to hand the floor over to you now, Phil.
Thank you, Peter. I think in order to really give some context to this story, you have to have the context around location. Chicago State University is on the south side of Chicago in the state of Illinois, which is probably one of the three most politically corrupt states in the United States. And that's sort of an objective assessment from political scientists like me, who sort of study political corruption and whatnot. We've had four governors end up in prison at some point. More than half of the city council, not at one time, but since 1972 in the city of Chicago, have ended up convicted for federal corruption charges. So it's embedded in sort of the DNA of the state, the county, the city, and its institutions. And Chicago State is really not any different from that. And so in 2009, when we got a new president, it was a very contentious process. It was a corrupted process, as academic presidential searches go. And as a member of the faculty senate, I believe I was the vice president at the time, it was important to us as faculty to say something about the direction that the university was going in. And there was no way, and I knew this at the time, that I was going to change the decision of the Board of Trustees in moving in this direction. There was no way to sort of convince legislators, or the governor's office, who ultimately has oversight over the Board of Trustees, to change this decision and to have a more transparent and fair process for selecting a president. What I could do, though, was use my voice. And what I decided to do was create a faculty blog to make sure that whatever transpired after this hiring was going to be done in public, in the light of day, and there was no ability to hide it. And it's sort of to take something from Lin-Manuel Miranda, being in the room where it happened. And that's what we were trying to create there. And so a colleague of mine from the history department, Bob Bionas, said, yeah, we should do this. And we got a few other sort of willing faculty who were willing to speak out on the blog, to speak out. The first couple of years or so, there was stuff there, and it wasn't, that big a deal. About the third year, we started seeing more sort of malfeasance on the part of the administration. There was some hiring irregularities. The president's girlfriend was hired into a job that she lied on the application for, which is just incredible to me. He creates a job for her and then she lies on the application. And thank God for FOIA, we FOIA'd all of that. And so on the blog, we provided the documentation and the timeline and all that, and all the necessaries to say this is improper. It was really after that, and then we had some other events that I'll get to, but it was really after that that the president and his general counsel began to take notice of the blog, and in a president's executive committee tried to appeal to my sort of softer nature and said, but people's feelings are being hurt by what you're publishing. And I said, is anything that I've published factually incorrect? And if it is, I will take it down immediately. Like a newspaper prints retractions, we sort of try to follow some journalistic integrity here. And he was like, no, it's not that it's not correct. It's just that people's feelings are hurt. I'm like, I don't know what to tell you about that. And so we continued. After that, we had an instance where we found that the provost, who was an interim provost and then appointed provost permanently, had plagiarized her doctoral dissertation. And we had the evidence for that. And Bob compiled a 16-page report with every instance of plagiarism, academic misconduct, essentially. And that made the front page of the Tribune. And it just sort of deteriorated our relationship with the administration from there, until the point that we got the most interesting letter from the general counsel that he was ordering me, as the owner of the blog, to cease and desist its publication on trademark violations. And he had this cease and desist letter delivered to my house, which was just incredible to me. And about 6.5 hours later, that was published in the Tribune as well. We were getting probably 400 hits a day on the blog. It was very much a local publication. It kept people who were working at the institution or interested in the institution sort of up to date with what was going on, sort of a paper of record, if you will. And the day after the cease and desist letter came, we had 13,000 hits on the blog. And so for them wanting us to not get attention, they did exactly the opposite thing. And it just sort of deteriorated more from there, to the point that, thank God, Fire was watching all of this sort of happening. We didn't reach out to them. They found us because we were really just sort of hanging on like, okay, are they going to fire us? Are they going to fire us? Are they going to fire us? Because we just would not stop. And they wouldn't stop with their misconduct, which was just incredible to me. Because every time they did something, we caught them, they were exposed, we got the documents and published it. Finally, it got to the point that we were asked, would we be willing to, because of the sort of constant barrage from them of trying to get us to shut down. It wasn't just the general counsel who sent a letter. They got an outside law firm to do that. That in July of 2014, Fire had retained DWT to represent us, and we filed our brief. One of the things they tried to do was institute a computer use policy that essentially was a muzzle on free speech at the university, which was clearly illegal, unconstitutional, and they wouldn't rescind it. And so we really had no choice, if we were going to maintain the principles of the First Amendment, which was freedom of expression, to become plaintiffs. And having been a plaintiff, having been involved as a witness in other cases, being deposed in other cases, being a political scientist by training. So I sort of have that intellectual curiosity about the judicial system and judicial process and that kind of thing. I still wouldn't recommend it to anybody of sane mind, to want to do this. You do it because it has to be done, because principles have to be upheld. And thankfully, fire recognized that, and DWT was willing to commit to our case. I think in some respects of the cases that the plaintiffs that fire has supported over time, I really think that we're sort of anomalous in the length of time that it took for the case to be resolved, and the lengths to which the institutions were just being obstreperous in their objection to changing policies that any reasonable person would see are not going to be sustainable in any sort of litigation. Our institution was very different. We had a general counsel who I characterized, and this is only because of my other interactions with him, as the worst lawyer in the history of lawyering. But it was really down to the client there, and that was the president of the university. Unfortunately, I think what happens, especially with public universities, I don't know about the privates, but with public universities, because there's no consequence for the people who really violate faculty rights or student rights, that they feel like, we'll just continue doing what we're doing with impunity, because there's literally no cost to them. I saw in the chat a participant in the webinar from Virginia, and I can say we're very much in the same situation in Illinois, that public institutions are represented by the AG's office, the Illinois Attorney General. In our case, and Ronnie can speak more clearly to this, the AG's office, I was willing to write up the settlement, and we would have been done in 6 months. It wouldn't have cost nearly what it cost. And the university fired the AG's office and decided that they were going to retain private counsel and all that cost. So I don't know if you can look at I think you can look at our story at CSU as sort of the worst, because the plaintiffs were really the worst. I think that that plaintiffs exist along a continuum. I think there are going to be some plaintiffs who are just malevolent in that regard. And I think that there are just some plaintiffs who are clueless about protecting the rights of faculty, and it's not done out of malevolence. And once they're caught, they go, oh, okay, we did that. We'll, let's correct that right away. And then I think there's a bunch that are sort of in the middle that you just sort of have to push on them a little bit to get them to cooperate. I think with faculty want to do what faculty want to do. It's our thing. It's the research, it's the teaching, it's the service. And we don't really want to get pulled outside of this. And yet, and I'll say this to my tenured colleagues, most importantly, tenure isn't just a privilege. Tenure is a responsibility. And it's a responsibility to speak, and to speak for those who can't really speak for themselves. Our untenured faculty colleagues, our adjunct faculty colleagues, our staff, be they civil service or AP colleagues, who don't enjoy the benefit of tenure. We have a responsibility to protect the higher ideals of the institution. And the only way we can do that is to speak. And when an administration decides that they're going to impose restrictions on that, then you got to take one for the team, really. And if it means becoming a plaintiff, do that, because the institution and your colleagues and the enterprise will be better for it. I'll end with that, and I'm open to any kind of question.
Well, we've had we've had the questions trickling in. We've already got a good number of them to work with. I'll continue on with the question that we had coming from Virginia, because it gets into it gets into some important territory, although territory that I think is probably outside the usual boundaries of the Faculty Legal Defense Fund's work, because it isn't something that can be because it isn't something that can be done quickly. It's something that is going to take more than 40 or so hours of legal work to do. But that is kind of how you change. How you change the incentives. The question we had coming from Virginia. I'll read it and I'll put it back out in the field. There is no cost and almost no impact for the individuals who can claim qualified immunity or for the institutions who commit the violation, so they are free to keep doing it. Unless the wrongdoers have to face the consequences of their actions, it will not stop. So how do we get around this? I don't know how you get around it other than, plowing straight through it, which is to say trying to, bringing a Section 1983 claim, trying to pierce an individual's, an administrator's qualified immunity. I can tell you from, I'm not from experience, I'm not a lawyer, I'm not a litigator, but I have been at FIRE for 13 years. And I can think of one particular instance where a case we've been involved with was successful. Ronnie may be able to think of others, but it was a case at Valdosta State University in Georgia, where a college president, and I'm sending this out to the chat now, where a college president summarily expelled a student with no due process whatsoever for posting a kind of online collage, sort of spoofing, kind of satirizing the president's role and the president's kind of inflated sense of self. For this, the president kind of unilaterally declared him a clear and present danger to the campus, expelled him with no due process, and it was such a it was such a blatant violation of his First Amendment and due process rights. This is at Valdosta State University, so a public university. That when it went to federal district court, they not only ruled for the student, but they stripped the college president's qualified immunity, which is to say that recognized that his actions were so far outside the clearly established boundaries of the law that he could not claim any pretense to state immunity, and that he was, as a result, liable personally for the damages to the student. That's one case where I can think of this happening, and I know from having run FIRE's individual rights defense program for several years. About half of my time at FIRE has been spent doing that work. I know there have been a couple of very sort of delicious exchanges that we've had with universities. I can't recall specifically which ones, but I know that there have been times when we've had some outrageously unconstitutional sanction being pushed against a student or faculty, and one very well placed phone call or letter to the university general counsel's office saying, just so you know, this is what the people who you represent are thinking is legal and constitutional today. And we've had at least one or two cases where the general counsel's office quickly intervened and made clear to the administration, like what you're doing is so illegal that we will not represent you, and we will say you should lose your immunity for this. So good people in the general counsel's office, I think that's one good way of doing it. But piercing Section 1983 is tough. It isn't really part of the defense fund's mandate, but it may to an extent be a part of our overall litigation strategy in terms of making it more and more clearly establish what university administrators can't do when it comes to the First Amendment rights of their students and faculty. I've spoken for a few minutes on this now. Ronnie, was there any gaps you want to fill or anything more that you'd put on top of that?
Yeah, Peter's being a little bit unduly modest. Part of the whole idea of stand-ups for speech was to change the calculus. And, James, you're right. At the end of the day, the state is going to wind up paying the legal fees. They're going to wind up paying any damages award. And in some cases, they might pay the punitive damages. Now, oftentimes, insurance policies won't pay for intentional acts, and typically you need some kind of real intentional act to get to punitive damages. So that's right. And the Valdosta State, the case that Peter's talking about, that was the first fire case I ever worked on, and they did hold the school president personally liable for the damages in that case. There was actually a jury verdict in that case. But the whole point of Stand Up for Speech was to change where the skin in the game lies and to change the calculus. It was, we're going to bring these cases and you're going to pay the attorney's fees. You commit the constitutional violation, that's not going to be on the student or the faculty member to take money out of their pockets to pay for a lawyer to defend them. You're going to pay for those fees. And we wanted it to cost something. Fortunately, a lot of the universities very early on settled quickly. The legal fees were small, the damages were small. But the whole point of the process was, look, if you're going to dig in your heels, it's going to cost you money. We told Chicago State at every step, as Phil mentioned, the AG was ready to settle that case based on the filing of the complaint. And on the verge of doing it, the president fired him. We got through the first round of litigation discovery. We begged them to settle this. This is just going to cost you more if you push this, because now the real work's going to start in briefing and everything else. They refused to do it. They wound up paying 2 to 3 times more than we told them they could get out of the case for. But the whole point of Stand Up for Speech being explicitly to change this calculus resulted in poor Peter being deposed in the Chicago State case. They said, "Oh, this is Fire's doing. We want to hear how Fire's behind all of this. We're going to depose someone from Fire." And Fire, they put Peter up there. I guess he drew the short straw. Phil had the indignity of being deposed also, but he was a party. He brought the case and was brave enough to do so. Poor Peter got dragged in just because Fire was tangentially involved, and he had to get deposed. And that's all we can do. I mean, look, it's not a good news story when on the front page of a paper it says XYZ University pays $1 million because they tried to get a faculty blog taken down, or because they refused to let this organization use the school's trademarks when they're letting everybody else use the school's trademarks, but they didn't like this one particular organization's viewpoint. It's unflattering. All we can do is hope that has an effect on the political process. I know that it's many steps removed. You're talking about political patronage position, so you got to get to the electorate. The electorate has to make different decisions. The elected officials have to make different appointments. It's many steps removed. It's attenuated, but that's how we make this happen.
That story of my deposition is a story that has never been told outside of the fire office. So there you have it. That did happen. I remember the day well. I remember where I was. I remember how bad the weather was that day. I remember that the guy deposing me was a dead ringer for a friend of mine from high school. It was a most interesting day. I think as to how I got there. I think I was one of the professor's first lines of contact, and I think when it got to discovery, they were like, "Who is this guy?" And they looked me up. They see I'm not an attorney. I'm not barred anywhere. They're like, "Privilege schmivilege. Let's bring him in." So it was, yes, it did go that far. I did get my hair wet a little bit on that one.
Yeah, well, and they put it in the court papers, and it got them absolutely nowhere. I mean, they tried to create a whole atmospheric on it, and the judge just was not buying. They like Phil said, they were doing everything they can to make this as painful as possible, and they paid the price in the long run.
Yeah. I want to bring this back a little bit to the fun, because we've gotten a little bit down the road from how work with the Faculty Legal Defense Fund begins, which is, as you said in your remarks earlier, Ronnie, ideally kind of at a very early point in a professor's case, and that's sort of that to my mind, as someone who was with RIDP for several years, who has sort of watched our litigation strategy take a couple of different forms. A lot of the times, obviously, when you litigate a case, it's because you have run out of all all other things to do within a university system. If you haven't, the first thing the court will tell you is go back and exhaust all of your avenues and then come back and see me. So that seems to be a really, really meaningfully different way that the defense fund operates from our other programming, in terms of trying to get kind of get someone there in the room with them early. Am I correct on that, Ronnie?
That's right. I mean, and I'll tell you why it's important, because a lot of times a university will have either a grievance process, or they will have some kind of process for doling out punishments. There will be a charge. There will be, a hearing before a faculty panel or something. Then there will be an appeal process. And I think sometimes because, the idea that I should have academic freedom and I should be able to speak my mind freely without the government in the form of the university punishing me for doing so, I think sometimes faculty can not these days, but in the past, can get lulled into this idea that, well, I'll just go through the process and, it'll bear out that, I can't be punished for this. And the problem is, as you're doing that, if it works, great. But if it doesn't, you are basically building the record for ultimate litigation, if that's where something goes, without the assistance of counsel. And P.S., if there is a different path that with experienced counsel, something might get pushed onto, rather than kind of this standard. I mean, they treat they treat every violation the same way procedurally, whether it's something you say or whether it's taking too many sick days or whatever it is. It all goes through that same process, and it's not always it doesn't lend itself to speech. So the idea is that the attorney that we refer someone to can get plugged in early, can go to the university and say, hey, look, you've got a constitutional problem here. This is your opportunity to stop it from getting any worse, from, not imposing any kind of punishment or, any kind of sanction that would be actionable. Because at the end of the day, Phil's right. No faculty member wants to sue their university. No faculty member wants to go through, the sanction and administrative process. They just want to do their jobs, teach the students, do their research, and speak their mind. And so if we can get someone plugged in early to help let the teacher focus on that, and ultimately get the university or college to leave them alone to do that and see the error of their ways, that's, I think one of the biggest values that, besides, paying for the attorney's fees, but that's one of the biggest values that FLDF can bring to this, is not having it blow up into a bigger thing, if at all possible.
And I have to give this sort of other political science-y kind of thing. I think higher ed specifically, faculty specifically, are soft targets in many ways when it comes to being abused. We've seen defunding of higher ed at the state level going on for many years. That's problematic. And we've also seen sort of attacks on faculty, attacks on tenure, and this kind of thing. And I hate to say this, but I think faculty are going to have to carve out the mental and physical space and time to become more political, in order to not continue to create an environment that allows these sorts of excesses of administrations to happen in the first place. I think that one of the failings of many public universities is that there's unions for faculty on campus. That to me says that management has failed, because they do not see the centrality or respect the centrality of faculty in the academic enterprise. And faculty, I don't think faculty want to be in unions, and yet they have to protect themselves some way. I don't think faculty want to be plaintiffs in First Amendment cases, and yet we have to protect ourselves some way. And I think it needs to happen along a continuum of political activity all the way to, if necessary, litigation.
Ronnie, and Phil, you may well have some experiences that you can attest to, based on, your time at Chicago State. But Ronnie, since we're talking about wanting to catch someone at an early stage of their issue before things get too far down the road, so we can have someone kind of there, they're proverbially in the room with them, as early as we can in the process. Could you maybe tell the people on the webinar some of the things that you would recommend in those early stages for them to you put them in the best position to protect their rights? What in terms of what the best portfolio they can kind of bring to you is in terms of documenting what they have going on?
Yeah, I mean, the trick is, and it's not always a clear line. There has to be more than just the possibility that the institution is going to do something, right? I mean, when it may be likely given a given circumstance, but there needs to be at least some concrete, and even if it's opening an investigation, that by itself is enough. Maybe it's just being called in for a meeting to be told you shouldn't have said that, or don't say that again, or whatever the consequences or whatever the instruction is. But the minute something like that happens, I would, to the greatest extent possible, communicate in writing, even if it's just email or even if it's just internal chat or whatever it is, so long as you can create a record of it after the fact. You want to create a record of that, and then you want to, anytime that you respond, you want to make sure that you are clear in your response, that you're asserting your rights to the extent that you can. You want to keep all copies of all that. And then the minute there's even anything that could fairly be called institutional action, and it doesn't have to be big, it can be something small, like, we're referring this to this office to look into. Even if there's a good chance that office might come out the right way. Waiting for that to happen is often not the best solution, because once the determination that someone has violated this policy or that policy has been made, it can't be unwrung. It can certainly be appealed, but if someone can get plugged in even before that happens. And by the way, for the First Amendment to be harmed, doesn't have to be a punishment per se. It just has to be enough that an objectively reasonable person would be chilled in their speech for it to be a violation. And simply opening an investigation on someone can certainly have that effect. And I would say, as soon as something like that happens or seems imminent, you want to reach out to ideally fire. You want to reach out to FLDF. Bring us the full story to the extent that it's developed at that point, and see what we can do. From the jump, before things get out of hand, or before the only choice is this a case we want to litigate? Because the truth of the matter is, oftentimes the kinds of speech that we're talking about, if it's getting sanctioned, it's because the institution is concerned about how it's going to look in the court of public opinion. And there's no guarantees in litigation, no matter how strong a constitutional case you have. I've had cases that I was certain were winners from the jump, and for whatever reason, the judge didn't agree. And so when you find yourself in that situation, the best thing you can do for yourself is kind of be proactive early.
Phil, do you have anything you want to add to that, or to kind of put that a little bit differently? Is there maybe anything you wish you had done differently at the beginning to better protect yourself? It sounds like from your description that you were a model of thoroughness in documenting things. A model that I would want others to emulate if I'm on the receiving end of your case submission. But from those early stages, are there any particular takeaways that you might pass on to other faculty who might find themselves one day in a similar position?
Yeah, I think there's a couple things. The first one is around understanding who your colleagues are. We tried to get much more support from faculty colleagues, and I'm talking tenured colleagues, because the way that I treat untenured faculty is very different. I want them protected as much as possible. They need to keep their heads down and not get involved in these things unless it's absolutely necessary. But tenured colleagues who are unwilling to speak up, I learned quite a bit about that, about how risk averse the people who have the most protection are in situations like this. I think the other thing that I learned, and it was really much more after the fact, and that was sometimes the tone that I took in some of my blogs, because I was so angry that the university was being placed in this position, that, you know, you've got a chief academic officer who plagiarized her doctoral dissertation, and that just galls me, right? And I was just very, very sharp in my criticism. I could have been less sharp and equally factual. So I think being mindful of tone sometimes is helpful in winning the public opinion battle. Other than that, I think your point about just try and document and have as much as possible to support you makes Ronnie's job a lot easier. If it ever is a he said, she said, but when there's a letter that's delivered that says, I'm infringing on your First Amendment rights, and here's the evidence, you can't ask for more than that. So look to just be thorough in the documentation, and be persistent, and be willing to understand it could be a long battle. It might not be over at the end of the semester.
Yeah.
Ronnie, oh, sorry. You look like you had something
I was
more
just going
to
to say, one question that came in is, how long can this take if it doesn't settle quickly? The answer is, it could take years. Discovery takes a long time. Cross briefing takes a long time. Invariably, somebody is going to lose on that. It may have to go to trial. Trials take a long time to prepare for and to have. If it goes to appeal, and there was an appeal filed in CSU, and the opening briefs were on file, and the response brief was in the works when we ultimately settled. It can take years. Like you say, Phil, it's not going to be the end of the semester.
This is different from the question I was going to follow up with, and I will follow up with that question. But with the talk about the length that some of these things can take, and your talk earlier, Ronnie, about just how many off ramps you tried to give the Chicago State administration, over the course of that litigation. Do you have a sense, and maybe you do, from having served as counsel in a number of these suits that we've coordinated, what does this look like from their end? What are their incentives? Like what could be the things that from the rationalizations that from our end can look galling, but might look sensible from the point of view of a university counsel?
I have to say that in cases that have dragged on, they take two forms. One form is like in CSU, where you've got a client who doesn't care whether they're right, and doesn't care if they're going to lose, because it's not going to be their hide that gets tanned. I don't know what a lawyer does in that circumstance. I just don't. I mean, the fact of the matter is, clients often get the lawyers they deserve, we like to say. I think that was true in that case. Other times, for example, we had a case that also went to the appellate court, and it was about protecting the school's trademark. They, legitimately didn't want it to be used with a certain viewpoint. And while, that's their interest, the First Amendment doesn't allow that. But they were going to, by hook or by crook, exhaust every avenue before they were going to let their trademark be used by an organization whose viewpoint that they disagreed with. I mean, and sometimes it's litigation strategy, right? I mean, they say, you know, the longer we drag this out, maybe someone will, you know, just give up. Maybe the professor is going to retire at some point and moot part of the claims, because any prospective relief, any injunctive or declaratory relief that the policies are bad, or that something that the school is continuing to do is improper, that gets mooted out if you don't have a party to whom that relief can flow anymore in the case. You know, it can, you know, there's a number of things that can drag these things out. And, you know, I do often wonder, I mean, but then again, if I'm still in the case and I haven't settled, it's because I'm convinced I'm right. So as far as I'm concerned, no one in their right mind would drag out a case against us for that long.
Ronnie, this may be the last question for the day, given that it is 5, and I want to be respectful of people's time. But this seems like a good question to kind of close the day out on, which is, you know, surely we get a lot of inquiries from faculty who are worried about what it means to bring a lawyer into the process at this point, not because of the cost, not because of what it might be costing them, you know, on an hourly rate. Although, as Ronnie made clear, we provide our legal services for the Legal Defense Fund free of charge to faculty. You know, but there are, you know, surely faculty who are worried about bringing in a lawyer because it might be seen by the administration as a kind of escalation. You know, that it sort of takes everything to another level, and they're just sort of worried about adding that degree of adversarialness to the process. What's the best answer that you have to a professor who comes to you with that concern?
Yeah, I mean, first of all, you know, you heard me refer to Phil and Bob as brave before, and I mean that because it's no small thing to take on A, your employer, and B, your employer, who in many cases is the size of a battleship, like many big colleges and universities are. Part of me wants to say, you know, much like in the context of criminal law, if you ask for an attorney, if you're, you know, have been arrested or are in a custodial interrogation, that fact can't be used against you. I'd like to be able to say that universities should not view the fact that you've wanted some counsel on your legal rights as upping the ante or making it more adversarial. I do live in the real world. However, I know that, you know, the same university shouldn't violate the Constitution to begin with for me to say they shouldn't, you know, take it the wrong way when you know, get someone on your side. What I will say is, I know who I'm putting into this network as I build it out. This isn't a volunteer network. This is me going out and finding attorneys that I feel comfortable with referring out to faculty who come to us. And I have full faith in them that they know when it's time to be the good cop, if you will, at the right point in the process. And when it's time to be the bad cop, they don't need 2 attorneys in the firm to do that. You're the good cop when you need to be and the bad cop when you need to be. I think there are ways to come into the situation as an attorney, especially when it's early on, and to try and act more as a facilitator and intermediary to try and get the parties to a solution that respects the Constitution and you know, doesn't really put the university in a position that they're, you know, going to feel uncomfortable living with. It's only when we get pushed to a stage where that's not possible that we go on. So I think that you know, you know, if you feel like you can be brave to assert your rights, do so. And I don't think you should be shy about having counsel, because, you know, good counsel, especially the kind of counsel that we're building this network with, especially when the incentive is to try and resolve it in the first 20 to 40 hours and to not have it go to litigation if it can be avoided. I think they're skilled enough to avoid the university thinking that it's time to go to war just because an attorney's come into it.
Phil, any last thoughts you want to add to Ronnie on that?
No, I think that's well said. And I think that would put most faculty's mind at ease, that they're not sort of gearing up for major conflict, but there's a way to resolve these conflicts, and the university is represented by counsel. Why wouldn't the faculty member be represented as well? I did want to say I did put my work email in the chat if anybody wants to contact me offline.
Yes, and thank you for the reminder. I meant to add, I will add my and Ronnie's contacts as well. And I have done so here. I think, unfortunately, we had so many good questions come in. I always feel, I say this every webinar that, halfway through, I'm like, okay, we can get through, we should make it to the end with the questions we have coming in. And then, and then you look and see it's 4:58 and you're like, oh no, I have so many good, outstanding questions that we can make another hour of discussion on if we want. Thank you. Well, firstly to Ronnie and Phil, this was an absolutely terrific discussion of a new and important new tool in FIRE's arsenal for defending faculty rights. And thanks to all of our Faculty Network members who tuned in. I will follow up with you by email with some more information about what we discussed this afternoon. And we should be doing our next one of these webinars in a few weeks. I'll be emailing our Faculty Network about that as well. But again, thank you so much to Ronnie and Phil. This was a terrific discussion. I know I found it very enlightening, and I've been at FIRE for 13 years, so it's always it's always great to be really enlightened by our own work. But this is taking things in an exciting, new, and necessary direction. So I'm excited. I'm excited to have Ronnie with us. I'm excited for the program, and I look forward to seeing what it does. And stay tuned because there will be surely more news to come over the summer as we ramp up the defense fund. So again, everyone, thanks so much. And stay tuned. We'll be back in a few weeks with the next one. And again, Phil, Ronnie, thanks so much for your time this afternoon.
Thanks, Peter.
Thanks,
Take care,
everyone.
Ronnie.
You too. Good to see you, Phil.
You too.